up maybe in the behind the court building.
Oh,
So
you know what?
instead of having her go out the front door,
It's just my part. You want, no, you can go. Yeah, I'll meet you in the front.
maybe in the behind the.
I'll get ready to start. Yeah, yeah.
Okay.
Okay.
Jefferson County Court at Law number 2 is back in session. Court is back in session with its bond forfeitures. First case is cause number 23 CCCR 1142. Case is style of state of Texas versus Devondrick Jermaine Berry. Devondrick Berry was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Devondrick Berry. Devondrick Berry did not answer. Devondrick Berry has not appeared in court since the court has been in session. The time now is 1:11 p.m. on today's date of February 27th, 2024. Ms. Bailiff, would you please call the name of Devondrick Berry at the courthouse door?
Yes, sir. Where's my time?
Devondrick Berry name was just called at the courthouse door. Devondrick Berry did not answer. A reasonable time has passed to give Mr. Berry an opportunity to appear in court. State, do you have a motion? That motion will be granted. Devondrick Berry's bond will be forfeited and the warrant should be issued for his arrest in cause number 23 CCCR 1142. Next case is cause number 23 CCCR 1152. Case is style of the state of Texas versus Sherry Marie DePola. Ms. Sherry DePola was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Sherry DePola at the courthouse door. Sherry DePola did not answer. Sherry DePola has not appeared in court since the court has been in session. The time now is 1:12 p.m. on today's date of February 27, 2024. Mr. Bailiff, would you please call the name of Sherry DePola? Would you please call the name of Sherry DePola?
Do you?
That's Ms. DePola?
No, ma'am. No, sir.
Oh.
Who is it? Call.
Sherry DePola's name was just called at the courthouse door. Sherry DePola did not answer. A reasonable time is given to give Ms. DePola an opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Sherry DePola's bond will be forfeited and warrant shall be issued for her arrest in cause number 23 CCCR 1152. Okay, state you excuse. Okay, this is clause number 23 CCCR 1934, case of Style State of Texas versus Donovan Washington. Or Donovan Travis Washington. Mr. Washington, again, would you please raise your right hand? Mr. Washington, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Washington, you may put your hand down. Okay, Mr. Washington, I have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there is a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. Washington, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. I also have a document before me, Mr. Washington, that's titled Judge's Explanation of Rights to Defendants Without an Attorney. It also has a signature at the bottom of this document. Do you recognize this document?
Yes, sir.
And is this your signature?
Yes, sir.
Now, initially, when you signed this document, you stated that you want to waive your right to an attorney to represent yourself. Now, since then, you've changed your mind and you're requesting a court-appointed attorney. Is that correct?
Yes, sir.
So, give me a pen. Mr. Washington, would you please get this document? You can, on that paperwork, where it says, you can just scratch through where you had that you wanted to apply, that you wanted to represent yourself, and on the line that states you would like to apply for court-appointed attorney, you could initial there. Okay. Thank you. Now, Mr. Washington, are these your initials on this line saying you would like to apply for court-appointed attorney?
Yes, sir.
And it's your signature on the line. Is that correct?
Yes, sir.
Now, Mr. Washington, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Washington, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. You stand here, and you can step back, and I'm going to go over these bond conditions with you. And the bond conditions reads as follows. Standard bond conditions in county court at law number 2. It says, following the return of a criminal information in county court at law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, he's got one. Condition number 2, the defendant shall not communicate either directly or indirectly with the alleged victim. Just tell him to have a seat.
Wait, I have to, you need to say.
No,
We said in the bond condition, he
Hey.
has to come back.
I thought he did that with his attorney when he was here.
No, he just said he didn't.
Oh, he didn't come to here for that though.
well, he's now.
I need to give him a copy of the receipt. Tell him have a seat.
The defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 2, condition number 4 does not apply. Condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing firearm or ammunition unless defendant is a peace officer defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, condition number 3 states that the defendant shall wear a global positioning monitor system device as at the defendant's expense with written verification being submitted to the court within 3 days. That's a GPS. Do you understand that?
Yes, sir.
Okay. Now, if you violate any one of these conditions, your bond will be revoked and a warrant will be issued for your arrest. Do you understand that?
Yes, sir.
All right. Now, your case is going to be reset. The information about who your attorney is and how to contact him is on that information sheet. You need to get with your attorney. She's going to tell you, give you information as how soon your attorney is going to contact you. If he does not contact you within that time frame, you need to contact him.
Yes.
Okay, and keep his case we're gonna keep your case on a Tuesday. Okay. All right, now just have a seat. And wait for her to call your name. And that's Mr. That's Mr. Rory Parker. Is that correct? Okay, Mr. Parker. You know what? I just saw that. Let me do this here.